Hi, my name is attorney Michael Goldstein. I'm a partner at the Law Office of Goldstein and Clegg and a partner with the Phillips Law Offices, as well as a host of the Consumer Debt Radio Show. Now, in my practice as a bankruptcy attorney, I get a lot of questions over and over again that really are very similar. And what I'd like to do today is address some of those frequently asked questions, the most common questions I get, and try and help people out there figure out really what is the deal with bankruptcy and really how does it apply to you. And the first question that I get very frequently is essentially, I'm making money, I'm getting income. Which type of income do I need to report to the bankruptcy court? What do I need to disclose? And it's kind of a loaded question because the short answer is everything. You must disclose all of your income, all of your assets to the bankruptcy court. Now, a lot of people will have income that frankly won't come into play in terms of, are you going to lose any of that income? Only if you're filing a Chapter 13 or Chapter 11 are you likely to end up paying some of that income back to the trustee, back to the bankruptcy court, which will then be redistributed to your creditors. However, the amount of income that you have based on the size of your family might affect the length of time that you're in a bankruptcy, particularly in a Chapter 13 if you're making a planned payment. But as far as income, if you have any wages, profits from business, you have any bank interest, stock dividends, royalties, income from real estate, really anything that you have, even if it's something as simple as every month you're getting a $100 gift from your parents or from your children, you need to report that. Now, the next question that I get frequently asked is, will filing from bankruptcy protect me from my creditors? And the answer is absolutely yes. Once you file a bankruptcy, pursuant to Title 11, Section 362, there's something called an automatic stay. What does that mean? It means that any creditor trying to get money back from you for whatever reason whatsoever is stopped. Big stop sign, essentially. Big red stop sign that says to the creditors, bankruptcy has been filed, you cannot collect. This is so strong that even if there's a foreclosure scheduled tomorrow morning and you file that bankruptcy tonight or even 5 minutes before the foreclosure proceeding, that proceeding is stayed. It's stopped. So the bankruptcy will protect you. The follow-up question I get to that is, well, what happens if creditors try and come after me after the bankruptcy? And what I tell most people when they ask that is, so long as you've listed your creditors, they're not going to come after you. However, in the rare event that somebody does, that automatic stay that we just talked about, it's still in effect. And whether or not your bankruptcy case is ongoing, no creditor can come after you for a pre-petition debt. Now, it should be noted that some creditors are going to say, well, look, I just didn't get notice. I didn't even know there was a bankruptcy. And in the event that that is actually true, in that you forgot to list a creditor, you simply have to point out to them that you had a discharge if it's a Chapter 7 case and it was a no asset case. If, however, there were assets that were liquidated, that then becomes a bit of an issue. And that's something that you really want to take up with a bankruptcy attorney in your state, because each state and jurisdiction might handle it a little bit differently. The last question that I get very frequently is relative to the value of assets. I always tell people, well, what do you think your house is worth? What do you think your car is worth? And I say, well, what does it matter? Aren't I protected? And the answer is maybe. Your house is protected up to the value that the law allows. And I know that's not really the best answer in the world to give somebody, but under the federal law, you can protect your house up to a certain amount. Under a state law, some states have declarations of homestead, where that homestead might protect you. And let's take Massachusetts, for example, because that's where I practice. In Massachusetts, you can protect up to $500,000 in equity in your home. But if you have more than that, then that is not protectable under the bankruptcy exemptions, and you have to address that somehow. Now, as far as being able to determine what the value is, typically I recommend looking at what the town or the city you live in assesses your property at. However, in the event that you are looking to do something a little more aggressive, such as stripping a lien or cramming down the value of a mortgage on an investment property or on a vehicle, you might need to get an actual licensed appraiser to come out and give you that written appraisal, which you will provide to the court in the various motions. Now, there of course are a host of other questions that we get, and if you have any specific questions, I'd be happy to address them. So give me a call. The office is 781-595-3800. Again, my name is Attorney Michael Goldstein with the Law Office of Goldstein and Clegg. Hope everybody has a great afternoon.